Greetings everyone. So I am Josh and David Gudisal and I will be tackling you a case which involves Bonifacio Olegario and Adelaida Victorino as petitioners versus the Honorable Court of Appeals, Manuel Rivera as Olegario and Socorro Olegario Tevez as the respondents. So this case is a General Register number 104892, November 14, 1994. So let us proceed to the back of the case. So the first part of the facts are the petitioners or plaintiffs' claims. So the Olegario couples were childless but reared and educated private respondents, Manuel Rivera, Paz Olegario, and Socorro Olegario Teves. Petitioner Bonifacio Olegario and Adelaida Victorino were the sole heirs of spouse Olegario. On May 23, 1989, they executed a deed of extrajudicial settlement of estate covering the subject lot published in the Metropolitan Newsweek for 3 consecutive weeks. On July 30, 1989, the settlement was recorded in the Registers of Deeds of Caloocan City, and a new TCP was issued in their name. Bonifacio and Adelaida sold the lot on August 1 for $200,000 to Elena Adaon and Nestor Tejon, and a new TCP was issued in the vendue's name. For the respondents or the defendants' claims, the private respondents, who only became aware of the extrajudicial settlement on October 21, 1989, attempted to register their contract of sale 3 years after its execution, which was denied since the subject property was already sold and transferred to Elena Adaon and Nestor Tejon. The private respondents, therefore, filed civil case number C13973 for annulment of the extrajudicial estate settlement and damages against the petitions. So here is the decision of the lower courts. According to the decision of the Court of Appeals on January 7, 1992, the extrajudicial settlement of estate executed by Bonifacio Olegario and Adelaida Victorino on May 23, 1989, as well as transfer certificates of title issued subsequent thereto, namely PCT number 190363 in the name of Bonifacio Olegario and Adelaida Victorino, and PCG number 190132 in the name of Elena Adaon and Nestor Tejon are hereby declared null and void, and without legal force and effect with respect to three-fourth portion of the subject lot pertaining to the latter. Moreover, the Register of Deeds of Caloocan City is hereby ordered to 1. Issue unto Adaon and Tejon a new title corresponding to the three-fourth part of the disputed lot. Second, to cancel TCT number 190363 in the name of Olegario and Victorino and TCT number 190132 in the name of the former. And third, to issue in lieu of thereof new title corresponding only to one-fourth portion of the subject property. Lastly, Olegario and Victorina are hereby ordered to pay Adaon and Tejon jointly and severally the amount of $10,000 as nominal damages and the further sum of $5,000 for and as attorney's fees. The appeal decision is hereby affirmed in all respects with no cost. So the issue is whether or not the deed of absolute sale was valid. So for the health part, we'll start with the disposition of the case. The judgment rendered on the 7th day of January 1992 by the respondent court has been reversed and set aside. The complainant in civil case number 13973 is also dismissed with no associated cost. In the dictum part, according to Article 1352 of the Civil Code, Contracts without cause or with unlawful cause produce no effect whatsoever. The cause is unlawful if it is contrary to laws, morals, good customs, public order, or public policy, which holds the alleged bill of sale is void. The unregistered nature of the 1986 sales contract is also readily apparent. The Property Registration Decree, also known as Presidential Decree number 1529, states that in Section 51, the Act of Registration shall be operative act to convey or affect the land insofar as third persons are concerned. This means that even in cases where the sale agreement is legitimate, its non-registration will not have an effect on third parties. More precisely, it cannot harm Nestor Tejon and Elena Adaon,